First of all, you have to have a lawful basis for processing the data. There are 6 lawful bases for processing data. There are really only 4 that apply to agents, so I'm going to look at just those 4 bases as we go through this. So the first lawful basis is a straightforward one. You have a contract with your client to sell the property. You have a contract with your client to market the property to find a tenant. As such, you can process their data, and you will need to do various things with that data. And so all you need to do when you have a contractual basis for processing data is tell the client what you're going to do with it. Who will you share it with? Who else will be involved in the processing of that data? Straightforward, no argument. You will have that in most cases. You then have a legal obligation. That's a lawful reason for processing data. So your legal obligation here might be under the money laundering regulations. It might be under the Estate Agents Act. It might be under the Housing Act. You have obligations under these pieces of legislation to do certain things with an individual's data, to obtain that data, to process it. So there is a legal obligation there. The third reason you might have a lawful reason for processing is that you've got consent from that person. That person may say, send me some details of a property. You'll take their name, you'll take their address. You might email them over to them, so you take their email address. They've given you consent to send them details of properties. They might want to view a property, so you'll have to take a bit more information. They might want to put an offer in on a property. They might want to apply for a tenancy. These are all consensual reasons for processing data, and so you have no problem as far as that's concerned. Make sure that they've given you clear consent for you to process that data. In practice, you probably should have something in writing from them, but that's not always possible in a practical sense, but you have to be able to prove that you have their consent for processing data. The fourth reason is that you have a legitimate interest to process the data. This is a new one. This is something that's potentially contentious and is in a conflict with some other piece of legislation that we have, which is the Privacy and Electronic Communications regulations. But it does allow you a reason for processing data if it's in your legitimate commercial interest to process it, and it doesn't override anybody's individual rights under Data Protection Act or under any other piece of legislation. There are 3 elements to legitimate interest. You've got to identify what the legitimate interest is. You have to show that processing is necessary to achieve it. And you have to balance that against the individual's rights, interests and freedoms. If you can do that, then you will have a legitimate interest to process it, and it's very contentious at this moment in time. Once you've got your legal reasons for processing data, then you have to make sure that you provide those people whose data you're processing with all the information that they need. So you have what's called privacy notices. We've all seen privacy notices on websites. That's just one way. Privacy notice on a website says, if you use our website and you enter data into our website, this is what will happen with it. You should have a privacy notice for your sales terms of business. So a client enters into a contract with you to sell a house. You give them a privacy notice which outlines what you do with their data. The same if you're entering into an agreement with a landlord. The same if you're entering into a tenancy agreement. Privacy notices should be everywhere. Websites, terms of business, even viewing requests. There should be a privacy notice that you provide to them. Maybe that you provide it verbally, but you should be providing it to them. You have an obligation to store the data securely. And the biggest issue that you will have is computer records. So you have to make sure that everybody who has access to computers has a login, has a password. You have to make sure that the passwords are changed on a regular basis. You have to make sure that people are aware they shouldn't share their passwords and login information with anybody else. You should ensure that computers log off or turn off when they're not used for any short period of time. You should ensure that you have appropriate virus software in place to prevent email attacks. The ICO even say that you should position computers away from windows where the public might be able to see what's on those screens. So take some steps to verify that you're doing all this. GDPR also says that you shouldn't store data for longer than necessary. It doesn't stipulate how long you should store the data. It simply says not longer than necessary. How long is that going to be for an agent? Well, in actual fact, it could be up to 7 years. There is a period of 5 years for storing the information that you hold on the identity of clients under the money laundering regulations. There is a 6-year period where individuals can take action against you through the county courts. There's a 7-year period that HMRC may be able to ask for information from you. So you have to assess the situation and make a decision about how long you're going to keep it and the justification for keeping it for those periods. You also have to make sure you dispose of data correctly. So simply throwing paper files in the general waste is not going to be sufficient. Simply disposing of computers in the electronic waste bin in a skip isn't going to be acceptable. You have to dispose of the data correctly.